At the outset, I should say that we are pleased that the court has been able to give judgment within a shorter time than I had indicated might be necessary. That's partly because the court is unanimous, which considerably shortens the time required, and partly because the judgment has been prioritized over less urgent matters. This is a brief explanation of the judgment handed down this morning. The full reasons for the court's decision are set out in the judgment itself. The Scottish Parliament was established by the United Kingdom Parliament at Westminster in 1998, when it enacted the Scotland Act. The Scotland Act gives the Scottish Parliament limited powers. In particular, the Scottish Parliament has no power to legislate in relation to matters that are reserved to the United Kingdom Parliament at Westminster. Those reserved matters include fundamental aspects of the Constitution of the United Kingdom, including the union of Scotland and England and the United Kingdom Parliament. Accordingly, if legislation would relate to the Union or to the Westminster Parliament, then the Scottish Parliament has no power to enact it. When the referendum on Scottish independence was held in 2014, an order in council had been made under Section 30 of the Scotland Act so as to enable the Scottish Parliament to enact the necessary legislation. The order in council amended the definition of reserved matters in the Scotland Act by providing that the reservations of constitutional matters, including the Union and the United Kingdom Parliament, were not to apply to the 2014 referendum legislation. The present case arises because the Scottish Government would like to introduce a bill into the Scottish Parliament which would provide for another referendum on independence, but the United Kingdom Government is unwilling to agree to the making of another order in council under Section 30 at the present time. So in those circumstances, the Scottish Government wishes, if possible, to hold a referendum without an order in council and therefore without any modification of the definition of reserved matters. The Lord Advocate, who is the senior law officer in the Scottish Government, has asked this court for a ruling on the question whether the proposed bill would relate to reserved matters and therefore be outside the powers of the Scottish Parliament. The Advocate General for Scotland, who is the Scottish law officer in the United Kingdom Government, has asked the court not to decide the question on the basis that it does not fall within the scope of the procedure for referring questions to this court, or alternatively, on the basis that the court should decline to decide the question in the exercise of its discretion. The court is not asked, and cannot be asked, to express a view on the political question of whether Scotland should become an independent country. Its task is solely to interpret the relevant provisions of the Scotland Act and decide whether the proposed bill would relate to reserved matters. The court has decided that it does have the power to decide the question referred to it by the Lord Advocate. Essentially, the court has interpreted the relevant provisions according to the ordinary meaning of the words used and has decided on that basis that the provisions are wide enough to include this reference by the Lord Advocate. It's also consistent with the rule of law that the Lord Advocate should be able to obtain an authoritative judicial decision on the legislative competence of the Scottish Parliament in advance of the introduction of a bill. The Court also accepts the Lord Advocate's argument that it is in the public interest that the Court should decide the question referred to it. The reference has been made in order to obtain an authoritative ruling on a question of law which has already arisen on a matter of public importance. The Court's answer will determine whether the proposed bill is introduced into the Scottish Parliament. The reference is not, therefore, hypothetical or premature. Turning to the question itself, the answer turns on whether the provision of the proposed bill, which provides for a referendum on Scottish independence, would relate to matters which have been reserved to the United Kingdom Parliament. The Scotland Act requires that question to be determined by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. Previous decisions of this Court establish that a provision will relate to a reserved matter if it has something more than a loose or consequential connection with it. The purpose and effect of the provision may be derived from a consideration of both the purpose of those introducing the legislation and the objective effect of the legislation. Its effect is not restricted to its legal consequences, but can include its practical consequences. Applying that test, the reserved matters which are relevant here are the union of the kingdoms of Scotland and England and the Parliament of the United Kingdom. The latter reservation has previously been held to include the sovereignty of the United Kingdom Parliament. The purpose of the proposed bill is to hold a lawful referendum on the question of whether Scotland should become an independent country. That is, on ending the Union and ending the sovereignty of the United Kingdom Parliament in relation to Scotland. The argument presented to the Court by the Lord Advocate that the proposed bill does not relate to reserved matters is essentially that because the referendum result would not automatically or directly bring about the end of the Union, it follows that the legislation does not relate to the Union. And because the referendum result would not automatically or directly bring about the end of the United Kingdom Parliament's sovereignty in relation to Scotland, therefore the proposed bill does not relate to the United Kingdom Parliament. However, as already explained, the effects of legislation for the purpose of deciding whether it relates to a reserved matter are not confined to its legal effects, but include its practical effects. A lawfully held referendum would have important political consequences relating to the Union and the United Kingdom Parliament. Its outcome would possess the authority in a constitution and political culture founded upon democracy of a democratic expression of the view of the Scottish electorate. It would either strengthen or weaken the democratic legitimacy of the Union and of the United Kingdom's Parliament's sovereignty over Scotland, depending on which view prevailed. And it would either support or undermine the democratic credentials of the independence movement. It's therefore clear that the proposed bill has more than a loose or consequential connection with the reserved matters of the Union of Scotland and England and the sovereignty of the United Kingdom Parliament. The Scottish National Party, which the court permitted to intervene in the proceedings, made further submissions based primarily on the right to self-determination in international law. They argue, in summary, that the limitations upon the powers of the Scottish Parliament, as laid down in the Scotland Act, should be restrictively interpreted in a way which is compatible with that right to self-determination under international law. The court is unable to accept that argument. The SNP rely on the judgment of the Canadian Supreme Court in a case concerned with Quebec. But in that case, the court held that the right to self-determination under international law only exists in situations of former colonies or where a people is oppressed, as for example under foreign military occupation, or where a definable group is denied meaningful access to government to pursue their political, economic, cultural, and social development. The court found that Quebec did not meet the threshold of a colonial people or an oppressed people, nor could it be suggested that Quebecers were denied meaningful access to government to pursue their political, economic, cultural, and social development. The same is true of Scotland and the people of Scotland. The SNP also relied on the submissions of the United Kingdom government to the International Court of Justice in a case concerned with Kosovo. But those submissions are consistent with the Quebec case. The government submitted that the right to self-determination under international law was normally limited to situations of a colonial type or those involving foreign occupation. That's not the position in Scotland. For all these reasons, which are set out more fully in the judgment, the court unanimously concludes that the proposed bill does relate to reserved matters. Accordingly, in the absence of any modification of the definition of reserved matters by an order in council under Section 30 of the Scotland Act or otherwise, the Scottish Parliament does not have the power to legislate for a referendum on Scottish independence. The court will now adjourn.